Now, gentlemen, we do have a question here, an email question that came to us from Lynn, and she wants to know about a bad car wreck. So listen to this. I was in a bad car wreck and spent 2 weeks in the hospital. Now, I just got a call from the hospital asking if I was going to pursue legal action against the other driver. What business is it of the hospital whether or not she pursues? That's a good question from Lynn. So, gentlemen, how do we start on that one?
That's a great question, Morgan. And let me set it up with the black letter law and the black letter example, and then Wendell can elaborate on it. Let's just say you're in an automobile accident and it's the other party's fault. Between your uninsured motorist and their liability insurance, you've got, say, coverage of $100,000 combined, and your medical bills are $150,000 or $200,000. The hospital wants to know, or the physicians want to know, whether you're going to pursue a claim or not, because they are subrogated to the extent that they have provided you with medical care and services. They are subrogated to get that money back from the at-fault driver or from the uninsured motorist carrier. So what is your leverage, Wendell, in that situation?
Well, what they are wanting to know is the information they need to file a hospital lien. And then they get all the money. And the injured party gets none. They're first in line. And the leverage you have, and this is why you should see an attorney, you got $150,000 in medicals, only $100 in coverage. Why should an injured party go through the turmoil, all that's got to be done to go through a lawsuit if they're going to get nothing out of it? And that's the leverage. The hospital under a hospital lien does not have a direct action against the at-fault driver. Only the injured party does. So you can say to the hospital, look, if our client's not going to get some money out of this, they aren't going to pursue the claim. Therefore, that money goes away. So if you do that, typically the hospital will say, let's split it a third, a third, a third, and everybody gets something out of it. And that's the leverage an injured party has that they can place on the hospital through an attorney. And that's why you should see an attorney.
And it's commonly done, but most people don't know about it. It's like playing poker, and the hospitals and the providers know, and they will divide it 3 ways if you have a lawyer who is aggressive with it.
Now, is that negotiable? Can they, sure. Do they have to divide it 3 ways? Or
they don't have to do anything. I mean, they really don't. They can insist on all their money, but the client may say, well, if you're going to do that, I'm not going to file a lawsuit. If I file a lawsuit and make a recovery, then I expect something out of it. So most contingent fee contracts are a third. So the lawyer goes to the healthcare provider or the hospital and says, look, why don't y'all take 30 cents on the dollar? We'll take a third under our fee, and then the client gets a third of the 100 that's available. That's kind of the way it's done.